is accurate, that it's up to date, and that someone's actually reviewing that information. You know, hand in hand with the credit application process is our next bullet point, which is personal guarantees and obtaining collateral. And a lot of times you'll be faced with a situation where you have a new customer and you certainly want to make the sale. Your company wants to make the sale, but there might be some concerns about credit. Personal guarantees are a great way if you have concerns about the ability of the company to pay, to get the owner, to get someone else to agree to guarantee that account. Certainly obtaining collateral is another great way, depending on the type of company and the type of debt, the type of credit that you're extending. Obtaining collateral may be another great option. Brent, before we go on with this, I did want to mention what I think is the number one question that I get asked about bankruptcy more than any other question, and that is, my customer filed for bankruptcy, but they didn't list my company as a creditor. Is my debt discharged? And that's by far and away the number one question that I get asked. And the answer, being a good lawyer, is going to be it depends. If it's a Chapter 7 case and there are no assets, then generally, yes, your debt is discharged even though the debtor did not list you as a creditor in the bankruptcy. If there are assets in the Chapter 7, or if it's a Chapter 13 or a Chapter 11, there's a possibility that you may not be included in the bankruptcy, but there's a lot more ifs and a lot more questions that need to be asked. But certainly as a practical matter, if your claim was not listed in a bankruptcy, it's something worth talking to your attorney about and determining whether that debt's been discharged and whether the bankruptcy applies to your company.
Brent, I think that, you know, even if you're not listed as a creditor on the bankruptcy, particularly if it's a Chapter 7 personal bankruptcy, you can be sure that at some point later in the process, that attorney that is assisting that debtor will not really reopen the bankruptcy, but will amend the bankruptcy, will request, you know, through the trustee that item be listed, especially if you pursue them.
And I've seen scenarios where the debtor's attorney, the bankruptcy attorney, has said, so what that you weren't listed? It's a Chapter 7. I'm not going to reopen the case. You're discharged anyway. And frankly, right. And like I said, in a no-asset Chapter 7 bankruptcy, that is the case. Brent, let's move on with how to minimize bankruptcy losses. Staying in communication with the customer is the next really great strategy for avoiding bankruptcy. A lot of times, your sales force is out there speaking with customers. You might read something in the newspaper or see something online about some financial difficulties that your customer may be having, or it might be something as simple as your customer starts falling behind on payments. But certainly, minimizing bankruptcy losses means staying in communication with the customer and also keeping up on the information that you have about your customer so you know where they're at in the process. I have some clients that on a daily basis will scan the internet, have certain programs for scanning the internet for stories about their largest customers so that they can know in a timely manner if there's any news out there that may impact the ability of those customers to pay. And I think it's a really great practice and something that that each company should look at with the wealth of information that is out there available to us on the internet and frankly through direct contact about our customers. Are there any questions about kind of early on how to minimize bankruptcy losses? Here again, we're talking about before the bankruptcy has even been filed. Does anyone have any questions or comments? Certainly feel free to chime in at any time if you have any questions. Brent, let's move ahead to how to pursue collections and repossession after a customer files for bankruptcy. So I think there's a real misunderstanding here that a lot of credit managers, a lot of creditors have, which is, you know what, your customer filed for bankruptcy, close the account, that's all you can do. And that's nothing could be further from the truth. Certainly if you're a secured creditor, if you have collateral, it's something that you can pursue, but you need to pursue it in the right way. And I see your first bullet point there is to pursue a motion in bankruptcy court for relief from the automatic stay. So if you have some collateral and the debtor filed for bankruptcy, you want to take a look at whether you want to bring a motion to repossess that collateral, especially if the debtor is behind on the payments. Sometimes the debtor will decide to continue making payments or might reaffirm a debt, but when we're talking about straight up collections, the first thing you want to take a look at as far as is going to be getting your collateral back. As everyone on this call knows, you can't just go grab your collateral after bankruptcy has been filed. You do need to get permission from the bankruptcy court and bring a motion for relief from the automatic stay. Some creditors, rather than bringing those motions, will wait in a Chapter 7 circumstance until after the Chapter 7 is discharged. I know that's our next bullet point, is these post-discharge collections, which really goes hand in hand with abandoned property as well. Brent, I know you have some experience with post-discharge collections as well as with abandoned property. Would you like to speak to that, please?
Absolutely. There's some good news here anyway. If there is another party in possession of your collateral or your property. In other words, the debtor themselves, the customer themselves, may have filed bankruptcy and had your debt discharged and everything else, but there's some property involved in it. Maybe it's an automobile, maybe it's a piece of business machinery, maybe it's a dish machine, maybe it's a mechanical, for construction purposes or something like that, a backhoe, whatever it is. Now, the good news is if that machine or that piece of property or collateral is in someone's building, let's say, you have a right to negotiate the release of that collateral with the building owner. Oftentimes that's not the actual debtor, customer. And in those cases, we have, our agency in particular has designed some programs to do just that for creditors that have assets out in the field. They've been sort of abandoned on the site, on the work site, or in the building that the customer was doing business, and we negotiate with the property or landowner to relinquish that collateral, because oftentimes the property owner or the building owner will come to believe, by way of the old 9/10, possession is 9/10 of the right, and so on and so forth, or by some other means, real or imagined, that they own that property, that collateral. And as we all know, in fact, they don't. And so we can help them understand that. And that can be done in a number of different ways. And like I say, it has to be done with a specialty, a specially designed program, if you're going to use a third party to do it, which obviously I would suggest as a collection agency owner here, I would suggest that you use a third party, but maybe you have staff internally that takes care of that too. But like I say, that kind of thing is well within your rights. So that's
and keep it in mind too, and I know, Brent, that's a great program that your company offers, and I think the thing to keep in mind with respect to bankruptcy is you still need to keep an eye on what's going on with the bankruptcy. If the bankruptcy is still active, you may need to get some permission from the trustee. The trustee may need to abandon the property, and there's a formal motion process that the trustee goes through to abandon property. So you just want to make sure if there is a bankruptcy that's pending, that you take a look at it, see what the status is of that bankruptcy, and you certainly don't want to be in a situation where you're accused of taking property of the estate. So it's something you want to proceed carefully, want to make sure you understand where the bankruptcy is in the process, but certainly waiting until after Chapter 7 is discharged and the trustee has abandoned any property is certainly a good strategy for pursuing recovery of collateral. Brent, let's move on to the next topic, which is considerations for continuing business with the customer in bankruptcy. And so a lot of times this happens where you'll have a customer that files bankruptcy. More often than not in these scenarios, it's a Chapter 13 or a Chapter 11, but it can also be a Chapter 7. And the debtor wants to continue to do business with your company. And so there's some guidelines regarding that. Certainly there's there's a way to do it. I actually, a big part of my practice revolves around negotiating these types of agreements with trustees, with debtors in possession, to determine what's the best way to structure such an agreement. You can see the first bullet point that I've got there is that any agreement to continue business with the bankrupt customer should be approved by the court or the debtor in possession. The debtor in possession is, in essence, the trustee, which is where the bankruptcy court has appointed the debtor to be its own trustee. And so you want to make sure that any of those agreements are approved by the court. There's also a process, and I don't have a bullet point for this, called assumption of a contract. And so if a debtor's in bankruptcy, and this we see in Chapter 11 context very frequently, the debtor's in bankruptcy but wants to continue. The company's in bankruptcy but wants to continue doing business with your company. The debtor will agree to assume the contract with your company, which means the debtor must, first of all, pay all arrears that accrued both before and during the bankruptcy, and then also make provisions to make payments going forward. It's great when it happens. It does happen in some scenarios. It doesn't happen in every scenario. Most often we see it where it's a service or some goods that the debtor needs to reorganize the business, and which goes to the next bullet point, which is getting paid as a critical vendor. Courts have created this category for certain service providers, certain creditors, to get this special treatment through the bankruptcy if they're deemed to be a critical vendor. And critical vendors started out being the utilities, electricity, but a lot of times it has morphed into a number of other areas as well. We've seen landlords treated as critical vendors. We've seen certain service providers that are critical for the continued business of the debtor being treated as a critical vendor. And when a company is designated as a critical vendor, that allows an opportunity for the debtor, while in a Chapter 11, to continue making payments to the creditor. Great circumstance if you can get it. And then finally, the third category that we put up there is... I don't want to interrupt too much here, but a gentleman by the name of Mark has posed a question. I'll let him keep his anonymity here. He's posed a question in the chat section of our meeting here to me. Critical vendors, do they usually pay old invoices? And I don't know if you saw that, John, but he posted that question just moments before we addressed the topic, and I wanted to make sure we snuck that in there to address that. Yep, critical vendors, do they usually pay old invoices? Yes, they should, because that goes to my next point, which is administrative expense claim, which you can throw up there as well. I take the position that if a company is going to be deemed to be a critical vendor, it's the same as assuming a contract, which means you have to pay all the old invoices and you have to continue with payments moving forward. So my answer would be yes. If your company has been deemed a critical vendor, the old invoices need to be paid. The other way to do it is to have the debtor in possession assume that contract. Of course, debtors are going to be very choosy about which contracts they assume and reject, but certainly, in my estimation, a critical vendor would have those previous invoices paid. As far as administrative expense claims are concerned, administrative expense claims are debts that the debtor incurs while the bankruptcy is pending. Here again, this is strictly in Chapter 11, but this is another great way to get paid. With administrative expense claims, those are paid as a priority through the bankruptcy. And we're going to talk a little bit more about the proof of claim process in a few minutes. But here again, I think the impression is someone files for bankruptcy, especially in a Chapter 11, and there's never going to be any payment to anyone. And the classic example I can give is Enron. Everyone remembers the Enron bankruptcy from like 2002 and what a disaster it was. But does anyone know what percentage of creditors were paid through the Enron bankruptcy? And it was close to 50 cents on the dollar. So a lot of times you look at these opportunities, and like I said, we'll talk about proof of claim, filing proofs of claim in a minute, but there are opportunities for creditors to get paid through the claims process in these bankruptcies. So when you see a bankruptcy filing, you're like, well, it's not worth my time to file a claim. That's a hassle. No, you should be filing those claims. In fact, there are companies out there that are premised on purchasing claims from you. Their entire business model is, oh, we see you filed a claim in this bankruptcy, we'll buy it off you for a discount so you don't have to deal with it anymore. Well, obviously they're making a profit off of it. So really there is money, particularly in Chapter 11 bankruptcies, and opportunities for creditors to recoup their losses. But you've got to know what you're doing, you've got to know what kind of claims to file, and you've got to know what kind of claims to make. Brent, let's move ahead to the next section, which is the customer incurs a debt and immediately files for bankruptcy. And in this instance, this generally happens in a Chapter 7 individual consumer action. And when that happens, there is a section of the Bankruptcy Code that protects the creditor, but warning, you're going to spend a lot of attorney's fees to pursue it. It is what it is. So Section 523 of the Bankruptcy Code provides that if a debtor files for bankruptcy and they'd obtain money, there's a number of exceptions. One is obtaining money under false pretenses, false representation, or actual fraud. Another is using a statement in writing that is materially false, respecting the debtor's financial condition. In other words, if they gave you a false financial statement and you extended credit to them, and you relied on that representation. And there's a number of other exceptions. I won't go through them all, but there are, in a nutshell, provisions in the Bankruptcy Code that protect creditors from a situation where a debtor obtains an extension of credit from your company and then immediately goes off and files for bankruptcy. So if you have that situation, I do recommend that you reach out to an attorney, look at the circumstances, look at the provisions of Section 523, and determine whether or not you can pursue that. To do that, to pursue a claim against a consumer or against a debtor who's filed bankruptcy after receiving an extension of credit under false pretenses, for instance, you do need to commence a separate lawsuit in bankruptcy court, which is where the expense comes in. But depending on the amount of debt that was extended, it's something that could definitely be worth consideration.
I'd like to jump in here. One of our attendees made a point to address the Canadian version of this, also known as the Bulk Sales Act.
Okay.
Which would be, I guess, like I say, the version of that process in Canadian law. So I just wanted to point that out, that somebody addressed that in the chat section of the webinar.
Perfect. I'm not licensed in Canada. I don't have a whole lot of experience, if any, with Canadian bankruptcy. So that's a great comment there. Our next bullet point under this section talks about what was the intent of the debtor, and ultimately, when we're looking at a customer who incurred a debt and immediately filed for bankruptcy, if I can boil it down to kind of what we need to look at, and there's a number of factors. Ultimately, the court is going to look at what the customer's intent was. Was the intent to take the money and never pay you back, or was the debtor's heart pure and it took the extension of credit and then ran into some financial difficulties and did not have the ability to repay? A lot of times proving someone's intent can be difficult, especially when it's intent to repay, but that is the standard that the courts will use.
It reminds me a little bit of the old theory that we have always talked about for years of piercing the corporate veil on a debtor that set up a corporation, mainly for the sole intent of borrowing money. And while that scenario does occur, it's again sort of hard to prove, but again, if the debt is substantial enough, it could be worth it. But it reminds me a lot of that.
That's a fascinating comment, Brent, and that's spot on, because like the piercing the corporate veil standard, where you're trying to go after the owners of a company for using a company as a sham, very similar here in what you're trying to do. You're trying to get through, in essence, the bankruptcy discharge by proving that the extension of credit was done for some wrongful purpose. So I think that's a very apt analogy between the two sections, and you're also right that the standard is difficult to prove, both with piercing the corporate veil as with getting an exception to discharge under Section 523. Doesn't mean can't be done. I've successfully litigated these 5 actions, and they can be done, but you have to have the right circumstances to do it.
That's right. Yeah.
Brent, let's move on to the next section, which is insider tips for getting paid through the bankruptcy process. So here's what happens many, many times. The debtor files for bankruptcy, and you get a Chapter 7 notice. Chapter 7 notice says there's no assets, don't file a claim, forget about it. You close your file and move on. 6 months later, you get another notice from the bankruptcy court from the trustee saying, hey, guess what, I found some assets, please file your claims now. Well, that subsequent notice from the trustee comes in, you've already closed your file, no one knows what to do with the notice gets chucked, no proof of claim is ever filed. There is so much money that is never claimed through these bankruptcies. It's stunning how often a creditor will miss an opportunity in a Chapter 7 to file a proof of claim. And here again, I had mentioned that there are companies that focus on buying claims in bankruptcy. There are companies out there that buy claims that are in Chapter 7. So they'll buy up all your Chapter 7 accounts, and you're thinking, well, what are those worth? Well, 1 out of every 100 or whatever number, the trustee actually finds assets, and there's actually a proof of claim that needs to be filed. These companies focus in on those, file those proofs of claims, and collect that money. So just because you have a Chapter 7, you definitely shouldn't do any further collection efforts on it. I'm with you there, but you should be keeping an eye out for subsequent notices that might be telling you to file a proof of claim. The other thing that's
you can actually use, aside from using just a specialty company to purchase those debts, those claims and file it for you, if you're running a business and you don't have time and you don't have resources and staff to handle that sort of thing, John, do you think it's a good idea to let, like a collection service or some other third party keep an eye on that stuff for you?
That's what all the big companies do. I don't want to say all, a number of large financial institutions will hire outside vendors just to track the bankruptcy notices. That's their job. Oh, we received a bankruptcy filing, we're going to send this account to XYZ vendor, who is then going to track the bankruptcy notices. So I agree. I think regardless of the size of your company, there's money out there in these bankruptcies, and it's just a matter of filing the claims and getting the money.
Yep.
Let's move on to oh yes, proofs of claims and carefully examine all notices. But let's talk about filing the proof of claim in a timely manner. The time frame to file a proof of claim is generally fairly short. It's a short window, generally 90 days, maybe 120 days. Sounds like a lot of time when we're all sitting here talking on the phone, but in the realities of business, you get the notice, it sits on someone's desk for a few weeks, goes to someone else, they figure out it's a bankruptcy, they identify the account. 90 days passes very quickly, and once those proof of claim deadlines pass, they're gone. So you really need to make sure that if you are going to file a proof of claim, most often we see the need to file a proof of claim in a Chapter 13, which is a wage earner plan, a plan of a consumer to reorganize his or her debts, or a Chapter 11, which is a business reorganization. So here again, critically important that you file those proofs of claim timely. Once those deadlines pass, they've passed. The next comment here is carefully examine all notices to ensure your claim is not disallowed. So you filed your proof of claim, you're feeling pretty good, you've done everything up until now, and you get an omnibus objection to claims. And on page 72 of the omnibus objection, on line 37, they'll see that they're going to try and disallow your claim. I've seen it happen, Brent, so many times. We have attorneys in our office who, that's their job, is to go through these complicated omnibus motions that are filed in Chapter 11s to ensure that our clients' claims are not being disallowed as some footnote in some exhibit to a motion. And so you do have to carefully, once you file that proof of claim, your work isn't done. You got to continue to really monitor the notices, read through them, have an attorney or a vendor read through them to determine whether your claim's been disallowed. And then I had mentioned already the final bullet point, which is that there are companies that purchase claims in bankruptcy let me tell you about one more thing that happens, and it happens very frequently. A company will file a proof of claim, but then it will fail to put the appropriate address on the proof of claim, or the company might move, the creditor, or for some other reason, the trustee cannot find your company to send you a check. And there are hundreds of millions of dollars of unclaimed bankruptcy claim money that is sitting out there, primarily from Chapter 13, some from Chapter 7s and Chapter 11s, that's being held that people don't even know about. So what I'm telling you with respect to these proofs of claim is, once you file a claim, well, first of all, make sure your claim is accurate, legible, has all the information that it needs, but also I'd recommend following up every 3 to 6 months on that claim to see what the status is as far as disbursements to creditors, to ensure that somehow or another the trustee hasn't missed paying you or sent a check to the wrong address. Are there any questions? Go ahead.
That's amazing how often that happens, that we see on the bankruptcies that we've monitored.
Yep.
You know, those things sneak through if you're not fully aware. So,
that's very true. Let's move on to our final section, which is the section that angers creditors more than any other, which is preferences. So the bankruptcy courts, the bankruptcy rules in their infinite wisdom as written by our Congress, has a provision that if a creditor receives payment within 90 days of the bankruptcy filing, there's going to be an argument for the trustee to make that you, the creditor, have received more than you should have, and that you have to return that money to the bankruptcy estate. So what happens is a creditor that's very diligent, that gets a debtor to pay within 90 days before bankruptcy filing, will get a demand 6 months or a year after the bankruptcy filing from the trustee, maybe even later, saying, hey, in the 90 days before the debtor filed for bankruptcy, you received X amount of money. You need to return that money to the estate as a preference. And the creditors come to me and they're like, wait a minute. I was diligent. I collected the money before the bankruptcy was filed, and now I've got to return that money? That doesn't seem right. And I agree, it doesn't seem right. It isn't right. But I've seen preference claims from thousands of dollars up to millions of dollars being made against creditors. There are defenses that we can make, and I'm going to talk about those in a minute. But it's something to be aware of as you're negotiating or dealing with a company that you think is in financial dire straits. You want to make sure that you're not in a situation where you're getting them to pay a bunch of money, and a few days later they file for bankruptcy, and then you've got to turn that money around. You got to turn around and pay that money back to the estate because a claim of a preference is made against your company. So a few strategies.
Give a perfect example of that in real life terms here. I had a client that did some advertising services for the automobile industry, and they submitted a very large claim to my office for collection, and we collected from an individual who had some very public legal difficulties here not too long ago, several years ago, but this individual became sort of infamous in our particular area as having created somewhat of a Ponzi scheme or something like that. But we kept an eye on that debtor closely enough to make sure our efforts ramped up before the 90 days or 120 days before he was forced to file bankruptcy. We collected a large amount of money from him, and they couldn't come back and file. We avoided the preference, in other words. And that's a real-life example of that.
Yeah, it's something you definitely want to be aware of if you know a company is filing for bankruptcy or an individual is. The amount of money that you receive in that intervening 90-day period can be crucial for you. So the first tip I've got up here is insist on payment up front or in exchange for goods and services. So if you decide you're going to continue to do business with a company that you think is in financial peril, well, payment up front, I know it's fantasy, it doesn't happen, but something to ask for. The other is to ensure that if they are paying you, in that time frame before the bankruptcy, if you think they're in financial dire straits, to ensure that that payment is in exchange for goods or services and not for some invoice from 2 years ago. And the reason because of that is, and it goes to the next point here, extending further credit when the customer is in default. The argument under the bankruptcy code as to why you need to repay a preference, money that was received in the 90 days before the bankruptcy filing, is because the argument goes, you've received more than you would have received in the bankruptcy. One of the defenses is what we call the ordinary course defense, which is where the debtor was making payments pursuant to ordinary terms between the parties. They were paying every 30 days. But if they're paying on an invoice from way back when, generally that's not going to be an ordinary course type situation. So, and this goes to my next point as far as extending further credit when the customer is in default. The customer is already in default and you're extending further credit, and I've had some clients that have made the decision to do that. You need to ensure that you're making it clear that the payments that are being received for that further credit are applied to that further credit, not applied to some previous default. Because if the money is applied to a previous default, that's not ordinary course. The money is applied to the credit that was just extended, that will fit in within the exception.
Gotcha. Say, just to interrupt you here, John, one of our attendees, Tim here, has made another good point concerning the Canadian side of these scenarios. And one of the Canadian laws or requirements is about proving the sale. You have to prove the receipt of goods by delivery signature, and that the serial number on the goods matched, what you sell to the company, to prove the goods actually came from your company. And that's a good point that Tim makes, that there's going to be some very broad similarities between the U.S. and Canadian laws concerning bankruptcy, but there's going to be these incidental differences that are definitely true. And I appreciate those comments in the chat section, Tim. I think it's good that we interject that in there, because I know we have some Canadian visitors with us here today, and like I say, at the end of our webinar, we're going to open everything up to question and answer. But again, feel free to chime in if you have a question right now. Otherwise, like I say, feel free to extend your questions at the end of the process. We'll definitely make a notice that we'll give you time to do that. But yes, these differences between the United States and the Canadian bankruptcy codes need to be pointed out when they come up. So I just wanted to make sure we were doing that as we moved along. So I apologize for interrupting.
No, definitely. I think it's a great point. And certainly here in the United States, it's a very accounting-intensive process to determine whether or not there's been a preference. We're taking a look at when invoices were issued, when the invoices were due, and when payment was received. And if you're looking at, a debtor and a creditor that do business on several different contracts over a period of time, it can be a very complicated analysis. There's no doubt about it. So it sounds like in some ways there are actually some similarities to the Canadian law as well. But like I said, I'm not admitted in Canada. I can't speak to Canadian law. Let's go to the final bullet point on this, and that's determining if payments were made in the ordinary course of business. And I've already touched upon this. Certainly, to the extent that payments in the 90 days for the bankruptcy filing are made in the ordinary course of business, those payments would deem to be not a preference. So for instance, if payments are made within the contract terms, if your contract says you need to pay within 30 days, and the debtor did indeed pay within 30 days, that would be an argument that this was an ordinary payment, ordinary course of business payment, and falls within the exception to being a preference. There's even a course of dealing exception, which is, well, the invoice said pay within 30 days, but for the past 10 years, this customer's always paid on day 60, and we can establish this course of dealing defense. We've had success in arguing that as well, saying, well, they didn't necessarily follow the contract, but they followed the course of dealing between the parties as to how payments were being made, and therefore it should be exempt from the argument that it's a preference.
That's a good point, because there are many companies that will not pay within your terms because they have their own policies, and they're big enough to back that up and kind of force the issue in the normal course of business. So that's a good point.
It's very true. Brent, that's all the prepared materials that I have. We can certainly open things up to questions. If anyone has any questions now, if you'd rather reach out to us after and ask your questions by email or by phone, we are available, so feel free to reach out to us.
Yeah, there's no question we'll be open to that. And John, they're probably concerned that you'll charge them a fee or something, but I doubt he will, just to answer questions concerning the bankruptcy seminar. So I'm going to send the bills,
any bills that are incurred, I'm going to send to Brent, so he's offered to pay
That's what I thought. Yeah, that's what I thought. Okay. But yes, absolutely. Are there any questions now? We'd be glad to answer anything that came to mind during the presentation. And if not, like John said, feel free to use one of those emails or one of those telephone numbers, and we'll be glad to answer in private as well. So again, no charge for that. So I'd like to thank everybody for attending this seminar. I hope we kept it brief enough so it didn't interrupt your day too badly. And again, any questions, please address either one of us. And we hope you all have a good day.
Thank you very much.
Thank you.
Thank you.
Thanks, everyone.